The Theft Act 1968 states the basic definition as: a person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. Now we can identify 5 elements to this offence, all of which need to be present for the offence to be made out. These elements are dishonesty, an appropriation, there must be property, which must belong to another person, and there must be an intention to permanently deprive the owner of it. The mens rea, dishonesty and intention to permanently deprive. The actus reus, appropriation of property belonging to another. So let's look at each of these elements individually. We'll start with dishonesty. If a person cannot be shown to have acted dishonestly, then he is not guilty of theft. Now, the Act doesn't tell us specifically what dishonesty is, but the case law helps from R versus Gosh, 1982, by telling us what 2 elements must be proved. The first is that according to the ordinary standards of reasonable and honest people, what was done was dishonest, which is objective. And secondly, if it was dishonest by those standards, the defendant realised that reasonable and honest people would regard the conduct as dishonest, which is subjective. Now, we can be sure of what dishonesty is not. A person is not dishonest if he had the belief that he has a right in law to the property, or the owner would consent if he knew of the appropriation and the circumstances of it, or the owner cannot be discovered by taking reasonable steps. Take, for example, Mr. Smith, who is owed £100 by Mr. Green. Mr. Green refuses to pay. Mr. Smith goes to Mr. Green's house and takes the canoe from his front garden that he knows is worth £100 in lieu of the debt. Mr. Smith believed he had a right in law to appropriate the property and was not, therefore, dishonest. In the case of consent, we can consider Miss Small, who is a lodger in Mrs. Singh's house. There's a knock at the front door from the window cleaner, who tells Miss Small that he's finished cleaning the windows and Mrs. Singh owes him the usual £10, as agreed. Miss Small doesn't have the money to pay, but knows that her landlady, Mrs. Singh, keeps some cash in a biscuit tin in the kitchen. She takes £10 and gives it to the window cleaner. Miss Small believes that Mrs. Singh would have consented to the appropriation of the £10 had she known of the circumstances, and is therefore not dishonest. And finally, it's possible that the owner cannot be found. Perhaps, walking through the supermarket car park at night, you find a pound coin on the floor. You look around, there's no one to be seen. The store is closed and there are no security guards. You've taken reasonable steps to discover the owner and believe they cannot be found. No dishonesty. Most of the offences of the Theft Act require proof of dishonesty as a specific component. The exceptions are burglary based on criminal damage or GBH, taking a vehicle without the owner's consent, blackmail, advertising rewards for return of goods stolen or lost, and going equipped for burglary or theft. In all other cases, it will be necessary to prove that the defendant was dishonest. A person may be dishonest notwithstanding a willingness to pay. It's 6 a.m. in the morning. Ahmed is walking to work and comes across a milk float. There are pints of milk on the back, and a sign saying that milk is £1 a pint. Ahmed looks around and can find no one to pay, so he takes a pint and leaves £1 next to the sign. He has demonstrated a willingness to pay, and so may not be deemed to be dishonest. Appropriation. Any assumption by a person of the rights of an owner amounts to an appropriation, and this includes where he has come by the property, innocently or not, without stealing it. Any later assumption of a right to it by keeping or dealing with it as an owner. Appropriate alone does not constitute theft. The other elements of theft must still be present. An appropriation may still be present even with the consent of the owner. In Lawrence v. MPC 1972, the defendant, a taxi driver, picked up an Italian student and took him to his destination. On arrival, the student offered the taxi driver £1. The taxi driver indicated more money was needed and took another £5 from the student's wallet, when in fact the fare would only have been about 50p. The defendant argued that he had not stolen the money because the victim had consented to the money being taken by him. But consent in the context of the law of theft means true consent with full knowledge of the relevant facts. The student in this case was not in full knowledge of the facts. Damaging or destroying property is an act of appropriation, as an owner has a right to damage their own property. However, in the absence of dishonesty, a charge of criminal damage is more appropriate. If a person, having come by property, innocently or not, without stealing it, later assumes any rights to it by keeping it or treating it as his or her own, then he or she appropriates that property. The classic example here is leaving a shop with products you've forgotten to pay for. The appropriation of the products was innocent. However, the point at which you realise you have left the shop with the products without paying and you keep on walking deciding to keep the goods, the appropriation becomes dishonest. Now, the offence of theft does appear to overlap with the offence of fraud. However, an appropriation requires an action by the defendant. A deception, which causes a victim to transfer money, will not amount to an appropriation and therefore no liability for theft. Where property, or a right or interest in property, is, or purports to be, transferred for value to a person acting in good faith, no later assumption by him of rights, which he believed himself to be acquiring, shall, by reason of any defect in the transferor's title, amount to theft of the property. So if the property is bought normally, for example a car at an auction, rather than a suspiciously cheap car from a stranger in a pub, he obtains ownership, even if it's stolen, and he should not be guilty of theft or handling stolen goods. Property. The Theft Act states that property includes money and all other property, real or personal, including things in action and other intangible property. Money includes notes and coins. Unless a person intends to give back the exact same notes and coins, they have the intention to permanently deprive a person of those particular notes and coins. In the case of R versus Velumil, 1989, a company director took money from the company's safe and claimed that he intended to return it after the weekend. The court held that unless he intended to pay back the exact same notes and coins, he had the intention to permanently deprive the company of the money taken. Money does not include cheques or credit balances held in banks and building societies. These are things in action. Things in action are things which have no physical existence but can be legally enforced. For example, a patent right, a debt, a right arising under a trust, or a right to overdraw an account, and cheques, etc. Whilst intangible property includes things like software programs. Real property refers to land and anything fixed to land, for example houses and buildings. However, land cannot be stolen unless a trustee or representative or someone who has authorised power of attorney deals with the property in breach of trust. So if Dave asks Diane to sell some land for him that has a market value of £30,000, and she sells it to a mate for £10,000 without ever putting it on the market, she has breached. Where a person is not in possession of the property, but appropriates anything forming part of the land by severing it or causing it to be severed. So when someone chops down an entire tree from land they do not own or rent and walk off with it, they have severed. Where a tenant appropriates the whole or part of any fixture. So if a tenant in a property takes the fireplace and kitchen with them, they have stolen land. So remember this: trustees breach, persons sever, and tenants take fixtures and structures. So that's how land can be stolen. Trustees breach, persons sever, and tenants take fixtures. A person who picks mushrooms growing wild on any land, or who picks flowers, fruit, or foliage from a plant growing wild on any land, does not, although not in possession of the land, steal what he picks, unless he does it for reward or for sale or other commercial purpose. So although the land is not his, he does not steal what he picks, unless he does so for reward, sale, or commercial purpose. So remember the 4 F's and the 2 P's: fungi, flowers, fruit, and foliage, and ask yourself, did they pick for profit? Note, this does state picking from a plant, and so does not include completely uprooting plants. For example, if you picked a tulip growing wild, you would not be stealing it. However, if you uprooted the tulip plant, bulb and all, you have severed it from the land and it is therefore stolen. Wild creatures, tamed or untamed, shall be regarded as property. But a person cannot steal a wild creature, not tamed, nor ordinarily kept in captivity, or the carcass of any such creature, unless either it has been reduced into possession by or on behalf of another person, and possession of it has not since been lost or abandoned, or another person is in the course of reducing it into possession. So what this means is that you can steal pets and zoo animals and monkeys from a wildlife park, but finding a dead rabbit after a shoot, when the members of the shoot have gone home having found all the dead rabbits they could, would not be theft, as the remaining rabbits have been abandoned. Personal property refers to tangible property and includes items in your house like a computer, a camera, or a TV. Personal property also includes prohibited drugs, even though possession is unlawful. So what isn't property? Property does not include human bodies, either dead or alive. Now it can include body parts or corpses if human skill has been applied that has resulted in them acquiring different attributes. Therefore, bodily fluids like blood or urine samples are property. In the case of R versus Kelly and Anor, 1999, Kelly was an artist with permission to draw anatomical specimens or body parts. These were usually used for training by the Royal College of Surgeons. Kelly and a technician removed the parts from the hospital. It included 3 human heads, 3 torsos, 6 arms, 10 legs, and part of a brain. Kelly made casts of the body parts for an art gallery exhibition. But because these body parts had become different from a corpse, and therefore acquired a usefulness or value, they became property that can be stolen. So remember, body or body parts can be stolen if human skill has been applied that has resulted them in acquiring different attributes. Neither confidential information, such as the questions on an exam paper, nor personal identity constitute property for the purposes of the Theft Act. Also, electricity is not property within the meaning of the Act, and therefore cannot be stolen. If you trespass on private land and unlawfully use a telephone, you haven't stolen electricity, but you have abstracted it. The offence of abstracting electricity occurs when electricity is used without due authority, or dishonestly wasted or diverted. When looking at property in relation to theft, it's also a good time to take a quick look at property in relation to criminal damage. You can see here that more land can be subject to criminal damage than can be subject to theft. And there are intangible things that can be stolen but cannot be damaged. Belonging to another. Property will be regarded as belonging to any other person having possession or control of it, or having in it any proprietary right or interest. So this means that a person may be liable for theft of their own property if it's deemed to be in the possession or control of another. In the case of R versus Turner, 1971, the defendant took his car to the garage to be repaired. The repairs were completed, the car was left on the road. The defendant returned and, without paying, took the car from the roadside and drove off with it. The defendant was charged with theft, and the court held that the property belonged to a person if at the time of the appropriation that person was in fact in possession or control of it. So, in this case, the owner of the garage and the mechanic can be seen to have control of the vehicle as well as an interest in it. Where property is subject to a trust, the persons to whom it belongs shall be regarded as including any person having a right to enforce the trust, and an intention to defeat the trust shall be regarded accordingly as an intention to deprive of the property any person having that right. And so property subject to a trust is regarded as belonging to the beneficiaries as well as to the trustees. Where a person receives property from or on account of another, and is under an obligation to the other to retain and deal with that property or its proceeds in a particular way, the property or proceeds shall be regarded, as against him, as belonging to the other. So when the property in question is given to a person with instructions to deal with it in a certain way, the ownership in the property is deemed to remain with the giver. Therefore, if a person receiving the property deals with it in a way which is inconsistent with the instructions, this can amount to theft. Davidge versus Bennett, 1984, provides us with a simple example. The defendant received cheques from her flatmates which were to pay for the communal gas bill. Instead, the defendant spent the money on Christmas presents and left the flat without paying the gas bill. The defendant was given the money with a clear obligation to pay the gas bill and failed, therefore committing theft. Where a person gets property by another's mistake and is obliged to restore the property to him, then the property shall be regarded as belonging to the person making the mistake, and an intention not to restore will be an intention to permanently deprive him of it. Where a person receives property by mistake and is under an obligation to return the property, a failure to restore the property will amount to theft. A policewoman who was overpaid her wages didn't return them when she eventually realised the mistake. Despite not withdrawing the money is a thing in action and is therefore property. The same applies if money appears in your bank account that wasn't intended for you, or is more than you're entitled to. Keeping it can amount to theft. If property is truly abandoned, it has no owner, and anyone who takes it will not be liable for theft. Ricketts took bags of clothing from outside a charity shop. Ricketts argued that the items had been abandoned and therefore belonged to no one. The courts held, however, that the donor of the bags had intended for them to be a gift to the charity, and so still belong to them until the charity takes possession. In another case, owners of a disused factory site had erected a barbed wire fence to keep out trespassers. What they didn't know was that there was scrap metal on the site. The defendant in this case took the scrap metal, claiming that it didn't belong to another. But if a person has control of a site, then they have control of the property in or on it, even if they're not aware that that property exists or have forgotten that it exists. It is important to establish whether property is truly abandoned and not simply lost. Taking a magazine to the dentist, reading it, then leaving it in the waiting room for others' enjoy, results in the property being truly abandoned. But losing a wedding ring in the snow and never finding it again doesn't mean it's abandoned, it is simply lost. Lost property is still regarded as belonging to the loser. Intention to permanently deprive. Now remember, all 5 elements of this offence must be proven for the offence of theft. If there's no intention to permanently deprive, then there's no theft. Section 6 of the Act tells us that a person appropriating property belonging to another, without meaning the other to permanently lose the thing itself, is nevertheless to be regarded as having the intention of permanently depriving the other of it, if he treats it as his own to dispose of regardless of the other's rights. And a borrowing or lending is for a period that in circumstances make it equivalent to an outright taking or disposal. So, it's still regarded as having the intention to permanently deprive even if the property is given back. For example, stealing a store gift voucher and then using the voucher in the store to pay for goods. Or, as seen in R.V. Lavender 1994, taking 2 doors from a council house to replace damaged doors in another council house. If you take property and treat it in a way that makes restoration to its owner unlikely or impossible, this can amount to an intention to permanently deprive. E.g., borrowing someone's wallpaper stripper and then moving to Australia with it. Or taking wallpaper from the factory you work in and papering your living room wall with it. Where a person, having possession or control, lawfully or not, of property belonging to another, parts with the property under a condition as to its return which he may not be able to perform. This amounts to treating the property as his own to dispose of regardless of the other's rights, if done for purposes of his own and without the other's authority. So this relates to pawning an item. If you lawfully borrow your neighbour's lawnmower, but then pawn it while they're away on holiday, even though you get the mower back and return it to the neighbour without them ever knowing it was pawned, you have parted with their property under a condition for its return that you may not be able to perform. You have treated the property as your own to dispose of regardless of your neighbour's rights. So remember, there are 5 elements to this offence of theft. All 5 must be present. There must be dishonesty and appropriation. There must be property, which must belong to another person, and there must be an intention to permanently deprive the owner of it.